Hello, hello, it's Patty Joe, and I'm gonna do at least one or two of these today because I go to work tonight and I work a whole bunch of days in a row. Um, Try not to work too many nights in a row because it's so hard on me. I'm getting so old. So, yesterday was my birthday. Thank you to everybody who said happy birthday. It was very sweet of you. Happy birthday to anybody who shares my birthday, and I don't know, I should probably say that every day to people because you know, it's a day. Okay, so, and I am in the middle of meal prepping in my slow cooker. That's a new thing to me, never had a slow cooker. And so I might have to take a couple of breaks to get that situated. We are on a new day for us 13 because I keep with the same channel. And I know it's like 15 of the trial, but I think this is going to be the Monday. We're still within his defense. Ugh. And this is where it's going to get really dicey. I think a lot of this is going to be pretty boring because a lot of this is going to be just Daryl not behaving. The grand meltdown, poobah. Oh my gosh. Shuffling his little papers. Ugh. Of course, my thing loops back. It's okay. It's okay. I think he knows his mother doesn't show up at this point. And look at how pale he is with those little horns, Satan horns, satanic Satan horns, little troll ears sticking up through his face diaper. Oh my god, my ear's itching underneath this. I don't know, I'm kind of fascinated with this where it's silent. Look at his fingernails. Ugh. Yellow was not a good color because the orange jail attire is showing through. Oh my god. Ugh. I wonder if we get like anywhere. Let's skip a little bit. He's got to be close. Speaking of nails. Gotta take my trash out today. It's raining, so I don't want to go clean up the dog poop. Yeah, he's nervous. Look at him today. This is fascinating.
Wisconsin versus Daryl Brooks, case number 21 CF 1848. May I have the appearances, please?
Morning, Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value in return for value all of the charging instruments in this matter and make my exemption available for the discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all my rights here this morning. All rights reserved.
All rights
All right,
reserved.
To you as well.
What a joke.
The records reflect the individual known to this court as Daryl Brooks is present in person in custody. However, he is wearing street clothes, a suit and tie, and a mask.
And for the record, I don't consent to being called.
Nobody cares.
It is noted. All right, Mr. Brooks, just preliminarily, do you anticipate calling any additional witnesses today?
For the record, I don't consent to being called that name. And what was the question?
Oh, jeez.
Do you anticipate calling any witnesses today?
I don't believe today.
Then
Well,
when?
we are-
Then when? Like next week? What a stupid idiot. You should be fired. Your client should fire you.
We're here for the continuation of testimony. The only witness that I'm aware of that's on your list that you added is your mother, Dawn Woods. So I would expect that if she's going to testify, she would be here. Otherwise, I will be going through the colloquy with you as to whether you intend to testify today or not.
Did you receive my ICS that I addressed to you?
Oh, I haven't looked. Let me look.
Actually, I addressed one to you and then one to the prosecution. Is the audio on?
It is. The audio's on. Do you know when you sent those?
Saturday.
Oh, his big yowzas.
So that would have been the
whammies.
22nd.
State receive anything through like the inter-office communication?
We have not, I just checked this morning to see if there's anything new. Nothing has been received at my office. And I should say the clerical that was assisting me went to the mailroom to double check. So not only has it not made its way to the DA's office, it hasn't even made its way over to the mailroom.
I can email the jail administrator to find out if there's anything in transit, if there's no objection from the parties, from the state.
No objection?
From you, sir?
No objection. I definitely want those documents received if they obtain important information.
They obtain.
You said you forwarded them to a staff member on Saturday?
Yes.
Do you know if that was morning, afternoon, or some other time?
Maybe afternoon.
And those are 2 ICF forms?
Yep, one addressed to you directly and one addressed to the district attorney's office.
sending that. I will send it with high importance and we'll see what response I get. But I don't have anything. If you want to generally tell me the topic, we can cover it verbally.
The topic is pertaining to exculpatory evidence. Some things were learned, and once they came to my attention, I felt the need to immediately address the court about this information.
All right, what information? Make an offer of proof for me, sir.
The expert witness for the prosecution in regards to, I believe it was inspecting the vehicle, Officer Ryan Schultz. Question was asked of, did he know if there were any recalls on that vehicle? And I believe that a Brady claim should be visited because there were in fact recalls on that vehicle. In fact, there were recalls on the Ford Escape models from 2008 through 2010 in regards to the throttle body malfunctioning and causing the vehicles to accelerate and not being able to be stopped. There is a class action lawsuit where the Ford company were sued because of this, and those vehicles, models from the year 2008 through 2010, were recalled. And that is very important information in regards to the vehicle in question being a Ford Escape 2010. This information is very easily obtained.
Okay, so my limited legal expertise, which is limited, like I don't even know the last time I got a speeding ticket. Okay, exculpatory evidence is evidence that they should have given him or should have in these boxes here or something, right? The discovery. So everything they knew, they give over. There's actually a case here in Baltimore where the state's attorney stated that they did not give a note to the defense that could have exonerated their defendant who spent 22 years in jail, blah, blah, blah. We'll go over that one because that is a case I do want to explore with you. So a Brady violation is when there's actual misconduct on the part of the prosecutor's office or the attorneys or whatever who should have known and given that information and used it, I guess, to and this could be like really big deal problems for their licenses and so forth and so on. And ethics violations, it goes into a lot of under things way above my head. So he's saying that they did this on purpose. And if this evidence should have been in the discovery, now he's saying the next thing he says out of his mouth is it was easily obtainable to everybody but Daryl, who's the victim, apparently. He so plays the victim.
Just by pulling it up and you'll see a class action lawsuit. Obviously, if it's a class action lawsuit, then it's pretty easy to...
So what's your request, sir?
My request is to find out if Officer Schultz knew, to find out if the prosecution knew that there was a recall on those vehicles. And in light of the fact that these vehicles were recalled because of this malfunctioning throttle body, for, I believe it's counts 1 through 73 to be dismissed.
Oh!
What's the response from the state, if any?
Whoa. Okay, so let's also discuss, and you guys can comment because you probably know way more than I do, but driving a lot of old cars because, I never wanted to pay more than $10,000 to $15,000 for a car. I never did either. I think one of my Bullet was a little bit over that, but it was under 20. So even my Mustang Bullet was under $20,000. I never paid too much money for a car. But when I started riding a motorcycle, some of these words became a little bit more like they do things from the fire department. They teach you how to check stuff, but they don't necessarily teach you all the words and all the mechanic things. But you know certain things. You're comfortable with certain things. So I was never uncomfortable with changing a tire or changing my oil or, certain things on my motorcycle that I can do. I can take the battery in and out. I can do that in a car. I can change the battery. So I think I expand upon what a normal, average female would do on a car. Now, do I do all those things myself? No. I often like to pay somebody because I like to do it. It's kind of like, when you get a little too far into something and then you get in trouble, that's me. I can get there. Now, the throttle, that's nothing but an accelerator. So to me, that is saying there's something wrong with the acceleration on this thing. But even the person who estimated his average speed during the attack only put him in the 30s. Now, that doesn't seem to be, but still with a 3,000-pound vehicle that's deadly. But that doesn't seem to be too fast until you understand and remember that a parade goes between 1 and 2 miles per hour. Between 1 and 2 miles per hour. The average person can walk, if you're walking for, say, exercise, up to 4 miles per hour, so maybe even a little faster. You're running a little bit faster than that. If you're a real athlete, maybe you're a little faster than that, but you're not like 10 miles. This is 30 miles an hour. That is fast enough to really do some damage. And if everything else is moving 30 times slower than you, but a throttle issue would tell me that it's some kind of surge in acceleration or an uncontrolled acceleration. But the opposite of throttle is brake. And I don't think that was the problem. And he's going at consistent speed. So this is not an issue here. Plus, didn't the guy inspect his exact vehicle, that exact vehicle, and went over everything and everything that could be verified and validated about the condition of it was? But he wants all 70-something charges to be dismissed. And then he can intimidate Erica out of the rest of them. Ugh.
Thank you, Your Honor. As Trooper Schultz testified during his
Here comes the annihilation.
Consistent with our research, there are no active recalls listed for the Ford Escape. As Trooper Inspector Schultz noted during his testimony, that Ford listed an extended warranty for the throttle body on the Escape. The warranty was extended to 10 years of age and 150,000 miles. The Escape is more than 10 years old and has more than 150,000 miles. Also, he noted specifically in his report that he did not note any defect in the throttle body as previously described in this report. There was no recall in the throttle body. NHTSA did do an investigation into allegedly defective Ford throttle bodies, which would have impacted this year. Basically, the electronic throttle body failures would have resulted in engine stall or surge while entering traffic from a stop position or while driving at highway speeds, neither of which I believe occurred here. Further, Inspector Schultz would testify that that does not prevent the brake from working. So
Two
if
separate
this
systems.
had been activated on this car, which it was not, but if it had been, and this defendant would have pushed down on the brake,
It would have reversed the
stopped
problem.
the car. Further, if this was a problem, there would have been the malfunction indicator lamp or the wrench light would have been illuminated, as Trooper Schultz or Inspector Schultz testified when he started the vehicle and checked the indicator lights. None of them were lit.
you.
Further, if there was this, he would have observed material buildup on the commutator. There was no such buildup observed. There were no problems with the throttle, electronic throttle body. That was part of his report. Therefore, this is, although there may have been some cars who had this problem, the car that the defendant was driving on this day did not have that problem. That was testified during the vehicle inspection. The defendant had the opportunity to cross-examine Inspector Schultz with regard to that. And again, in running the defendant's mom's VIN number through NHTSA, National Highway
Traffic Safety Association.
Traffic and
Administration,
Safety.
something.
Administration. There are, for this particular VIN number, for this car that the defendant was driving, 0 unrepaired recalls. So it's a mood issue.
I don't believe it's a mood issue, and I actually have. The report should be in the mailroom as we speak. I had everything sent over priority mail. The actual information about the class action lawsuit, the actual information about the
That has nothing
the
to do with
recalls
anything
for
with
those
your
models.
car.
Like I said, 2008 through 2010. Now, in all fairness, Your Honor, that's why I was asking for a Brady claim on this. Seeing as how when vehicles are purchased from the manufacturer, they're still sold as is. There would be no way to know that there's anything malfunctioning with the vehicle until it actually happens. And seeing this a class action lawsuit, no one would sue the Ford company if there weren't malfunctioning vehicles. There would be no class action lawsuit.
How does that go together?
If these vehicles were not malfunctioning. And I believe with that, like I said, the information is easily obtainable. I should have the information in the mailroom right now that you can readily view this information about the class action lawsuit, about the recall. It wasn't just the 2010 model in question, it was 2008 through 2010. The information about the malfunctioning pertains strictly to the throttle body.
Let me address your claim, sir. So, not trying to cut you off, I don't need the specifics about a class action because as it relates to this case, the fact that there's a class action would not mean there's a Brady violation by the state. In fact, you even indicate it was readily known and something you were able to find out. I'd further note that you had a full and fair opportunity to cross-examine the inspector regarding his mechanical inspection. It's not new information. And more importantly, as it relates to this particular vehicle, based upon the testimony of Inspector Schultz, it's speculative as to whether this vehicle would be impacted, number one, by the class action, and number two, any throttle body problems. Because, again, there was a full inspection. That report was provided to you. He testified on direct examination about there being no active recalls, and more importantly, he testified about what impact the throttle body would have and what he would expect to see if there were any issues with it. I am aware that the ICF, I did receive an email, it's one page with what you said. I have to turn my head, I gotta figure out how to flip it. So give me a second.
Okay. Just for the record, Your Honor.
Hold on, let me finish my record, okay? So I'm going to turn, because it's the only way I can read it. It says, your ICF says the state's expert witness who did the inspection on the vehicle in this incident needs to be recalled no later than Wednesday. I just learned of some information that is extremely vital.
That is
So
not.
I understand the information that you're providing me, but again, you had a full and fair opportunity to cross-examine this witness. This information was apparently well known. I'd also note the vehicle's registered to your mother, and from my understanding of recalls, I think what is common knowledge is that a registered owner would receive information regarding the recalls and what to do, and presumably she would have provided that information to anyone operating that vehicle or taking care of it. We have none of that information before us by way of fact or even an offer of proof that even she received that information and did nothing with it, or whether anyone else who operated that did anything with it or not. The bottom line is there is absolutely no Brady violation by the state. This is not the type of information they would have been required to turn over. And from my understanding and review of Exhibit 83, what's important to this case is that the mechanical inspection specifically looked at that issue nonetheless and found that as to this particular vehicle, there were no issues with that would have impacted the mechanical function during the incident in
all of his
question.
contradictory
I'll accept the
garbage
state's
out of the
offer
water.
of proof as to what would have been the issues based upon the information provided. And again, without anything further from you by way of your offer of proof, I can't make a finding, number one, that there's a Brady violation, and number two, that the information you seek to cross-examine him on would have any impact whatsoever. So I'll deny the request to dismiss the case, and I'll deny the request to recall this witness.
Wow.
Your
Hold
Your
on.
Honor.
Hold on. Let me have the state just make their statement. I'll give you the last word on it. Go ahead.
The Inspector Schultz's mechanical inspection report was provided to the defense on April 29th, 2022. I noted that when the defendant was cross-examining Inspector Schultz, he did have the report in front of him, and it was asking questions directly related to information contained in that report.
All right. Go ahead, Mr. Brooks.
When you spoke to the owner of the vehicle, that's who gave me the information. My mother gave me the information of this. I had no knowledge until she told me. And that's how I came into the information. And she was the one that said, I'm going to send you all the information that you need so you can present it to the court. So I
understand that, sir, but your request
information.
is not timely. So you have had this information for quite some time, either through counsel.
I did not have it for quite some time.
Let me make my record. Either through counsel.
It was just told to me.
That's not what I'm saying. You've had the information about this report for quite some time, either through prior counsel or through all of the discovery that was turned over to you when you took over your representation of your own case. The fact that you have now learned this, it's a little bit too late. And I understand that may seem fair to you, but even when I consider the information that you're providing to me, it's speculative on your part as to whether there's any impact on this particular vehicle because of the inspection that was done. And you had a full and fair opportunity to cross-examine the inspector about information that was readily obtainable and researchable by you prior to the time that you cross-examined this witness.
It was not readily available for me to expect at the time. I don't have access to the internet. So how would I be able to...
Mr. Brooks, you're telling me your mother had that information.
No,
so,
I'm
and
telling
gonna
you, she just told me this information. I have the phone calls to prove it.
I understand that. I'm denying the request, sir.
And I would like
So
object
that's
to
my
that.
decision.
I object to that, Your Honor.
I understand.
I
I've made my
object to that.
decision. I expect that you respect the decision, at least
No.
that we're not going to debate it further.
Yes.
Yes.
I now have the
It needs to be-
ICF,
It
the
needs
one
to
from
be
the state
addressed,
that
Your
provided
Honor.
to the
Doesn't need to
state.
be addressed.
Madam
needs to
Clerk,
be
I just gave
addressed.
that to you. All right, so
I
Mr. Brooks, in
respectfully
light of
object.
that,
I respectfully object, Your Honor, and request the legal reconsideration of your ruling, Your Honor.
it's denied. The request for reconsideration is denied. There's no legal basis for me to do
I
that at this point.
respectfully reject that ruling and take exception to that ruling, Your Honor.
All right, Mr. Brooks, we need to keep going.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
I provided an oral ruling today. The record stands, sir.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue?
Your request is denied.
For the record, may I respectfully move for an interlocutory declaratory appeal of this matter?
I wouldn't be the one you would make that request to, sir. So I
For the
can't
record, may I
answer that
move
yes
to
or
stay
no.
these proceedings until the instant matter is adjudicated by a court of competent jurisdiction?
The request is denied.
Based on what law or fact, Your Honor?
The request is denied.
Based on what law or fact,
What,
Your Honor?
any other requests, sir? I'd like to move on.
Based on what law?
There's no
Or
legal
fact.
basis that you've stated for me to do that, sir.
It has been, Your Honor.
The request is denied. The request is not a proper motion. There's no legal support for the motion. There's no factual support for the motion, so it's denied.
For the record, it appears that this court is acting in contempt of the law, Your Honor. Can you show me how or where this court is following the law of respecting this matter?
That's a very vague statement, sir. There's no legal relief that you're claiming. There's no motion before the court based in law or fact. So this court cannot address that last statement of yours.
Your Honor, with all due respect, I would like a motion for finding the fact.
Denied.
Under what law and fact?
I
Your
made
Honor?
an oral ruling, sir. There's no requirement I do so in writing.
So you're denying a legal, you're denying a motion for finding the fact.
I am.
So how do I know what you're doing is legal, Your Honor?
All right, Mr. Brooks, we're going to move forward. At this time, I want to,
How do I know that this is legal, Your Honor? Can you show me that it's legal?
Mr. Brooks, we're moving forward. So your
Doesn't
request
seem
is
like
denied.
it doesn't seem
Mr.
like
Brooks,
you're-
I need to give you some
It
advisements,
doesn't
and I'd
seem
ask
like
that
you're.
you
I
stop
don't
interrupting
need your
me.
advice.
No, I have to
need
give you
you-
advisements, sir, regarding
I
your
need
right
you
to testify.
I need to do your job without prejudice and without
Mr.
bias.
Brooks has
Your
now
Honor.
interrupted me multiple times. He's failing to respect the court's oral rulings here today. It's something that he's done repeatedly.
What she really wants to say is, Mr. Brooks thought he was going home today, and now he's going to throw a humongous tantrum because we blew all of his theories out of the water. He came up, instead of preparing any defense, instead of saying, I do think something was wrong with this car. I know they didn't find anything, but this is what I felt, whatever, or I was afraid and I was running from there. Any defense. He came up with this.
Throughout this trial, Mr. Brooks, I need to go through some advisements. Unless you have a witness to immediately call, I need to go through this particular discussion on the record with you regarding your right to testify.
You don't need
Do you
to
have
go
a
through-
witness to call,
You don't need to go
sir?
through anything with me on record.
He's right about
Actually, I
that.
do so,
Actually,
sir.
you
That is
don't.
required by
Actually,
law.
you don't. You need to do your job as a public servant
Mr. Brooks,
and honor the oath that you
I
took.
need to
Your
go
Honor.
through these advisements,
Under
and
the
if you're
oath.
going to keep interrupting me, you will forfeit your right to be present, and you
So
will
you're
be
holding me in
removed
contempt
to the next courtroom so that I can properly go through these advisements
And
without
I
being
still-
interrupted.
And I still don't have to answer. I still don't have to answer whether I'm in this court or not. So you're holding me in contempt
Whether-
yet again.
Mr. Brooks, I've not held you in contempt. I've found that you have forfeited your right to be present by your conduct, which is one of the options available to this court under Illinois versus Allen, under State versus Vaughn. It's also referenced in State versus Anthony. So I am going to keep going, sir, despite your protestations.
Your Honor, with all
I need
due
you
respect,
to
in Illinois
not
versus
interrupt
Allen,
me.
in
This is
Illinois
another
versus-
interruption.
In Illinois versus Allen.
Mr. Brooks,
do
I'm
they
not
say-
going to have a debate with you on
I'm
the
not
meaning
trying to
of
have a
Illinois
debate.
versus
I'm not
Allen.
trying
You
to
are
have a debate.
you
I'm
are
merely
advised
trying
that
to
it
understand
continued.
Illinois versus Allen.
Mr. Brooks, you are advised that continued interruptions will result in you forfeiting your right to be present during this next phase of the trial.
Okay, but you saying that
I've said
forfeiting
that
my
multiple
right.
times.
You
I've
saying-
given you multiple opportunities
You're
to
holding
stop
me in
interrupting
contempt.
me.
You're holding me in contempt.
Mr. Brooks,
By
I'm not holding
removing
you
me
in
from the
contempt for
courtroom.
the second time here, and I've
Your
also
Honor.
repeated that.
Your Honor,
He's
with all-
interrupting me yet again.
with all
Mr. Brooks, I
respect-
need you to stop talking.
With all respect, in Illinois versus Allen.
All right, Mr. Brooks continues to want to debate with me the meaning of Illinois versus Allen. It is a clear indication to this court
trying to
that
understand,
he
Your Honor.
wants to disrupt these proceedings, even
That's
in
not
a
true.
mild manner tone
That's
of
not
voice.
true.
I've
I'm
reminded
seeking
him
to
repeatedly
understand, Your
regarding
Honor,
sanity
because it
and
doesn't.
civility, and one of the
Illinois doesn't.
bedrocks is that you
Illinois
not
versus
interrupt.
Allen does not state.
All right, I'm going to
that-
remove him to
Oh
the
my
next
goodness.
courtroom so that I can go through
It does
proper
not state-
advisements with him without being
It
interrupted.
does not
We'll clear the
state
courtroom
that
and
you
we'll
can be
resume
present from
once he
cameras.
is over there. Again, I'll
It
make
doesn't
the
state that
appropriate
you can be
findings when
present
he is
from
there.
cameras, or that you could be,
Yes, we're off the record.
or that you
until,
could be.
he's in the
Okay,
other
so
courtroom. I'll
you're
be
making a
stepping off.
tacit agreement for something that I.
He's exhausting. He's absolutely. This whole day is gonna be just this. I guarantee it.
Courtroom.
Yeah.
I believe I gave that warning at least twice.
That was perfect.
Of course, this comes on the record before this court over the first 15 days of trial, where Mr. Brooks has, by his conduct, forfeited his right to be present on a number of occasions due to his conduct. I do appreciate that this morning he didn't yell at me, he didn't raise his voice, he didn't speak in an angry tone. But given the history in this case leading up to today, and knowing what this court needs to get through in terms of whether he has any witnesses or whether he intends to testify himself, there's a very important colloquy I need to have and an advisement of his rights that I need to go through, and I simply am not able to do that with him constantly interrupting me and then not respecting the oral rulings that are made. Of course, at any point in time, Mr. Brooks can ask to be brought back over to this courtroom under Illinois versus Allen. Of course, he needs to pledge that he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. I, of course, have repeatedly, even without him making such a pledge, brought him back into the courtroom where I felt a sufficient time has passed, and he, at many times, has been able to conform his conduct. I would note during the vast majority of the testimony that was provided during the state's case, he was in the courtroom, if not during the entire time. He was able to cross-examine witnesses. We had a couple of issues during the testimony of witnesses he called, and of course, last Friday was, in my opinion, probably one of the most challenging days, I should say, to date. It's my hope that we can continue with Mr. Brooks in this courtroom. At some point today, I'll certainly invite him back over when I get through these advisements. Mr. Brooks, you have been muted. I will make that, put that on the record as well. I will unmute, though, and ask Mr. Brooks, because you did not answer the question previously, other than you potentially testifying on your behalf, do you have any other witnesses present at the courtroom, at the courthouse, to call today? I need an answer to that question, sir.
matter jurisdiction that we haven't addressed when I was just over there, or since I've been over here? Are we addressing subject matter jurisdiction?
I'm going to mute him just for a second. No, I'm not going to address subject matter jurisdiction. This is a common ploy by Mr. Brooks. When I attempt to go through certain things with him, ask him questions, he tries to divert our attention away to subject matter jurisdiction. I have issued a written decision on that. He has not filed any type of interlocutory appeal regarding that. This court's position is there is subject matter jurisdiction, and I'll deny verbally and orally at this point.
Let's skip forward a couple seconds because we don't need to hear this again. I don't know why she's clarifying it for the record, but ugh, it's just exhausting.
For her to be here. Are you going to call Dawn Woods as a witness this morning, and specifically now? I will ask him a second time. Sir, do you have Dawn Woods available to call as a witness this morning? He's been unmuted though, for a while now. We can obviously hear him. I will ask Mr. Brooks a third time for the record. He's finally putting on the headphones.
Oh, jeez.
Is Dawn Woods in the courthouse available to testify right now? Do you intend to call her?
Hold on.
Is this how he talked to Erica or any of the other women? Who would have sex with that? Who? Ugh. The way he talks.
For the record,
to
Mr. Brooks
anybody.
only puts on the headphones when he's in the other courtroom. He does not put them on when he's in here. The audio and the visual work just fine in that courtroom.
When I'm in the actual courtroom, I can hear it. I don't need to be muted.
Muting
Mr.
doesn't
Brooks' statements that the
hearing.
audio doesn't work when I mute him is simply false.
Correct.
I didn't say nothing about the audio not working, so you need to stop lying on the record.
I'm not lying on the record, sir. I've
You are lying
confirmed.
on the record.
All right, I'm going to mute him once again because now he's raising his voice. Now he's angry. He's thrown the headphones. He certainly does not seem to want to answer any of the questions this court has. I asked him 3 times if he had any additional witnesses to call. I warned him that if he did not answer that question, he would forfeit his right to call additional witnesses, other than perhaps himself. I then specifically asked him about Dawn Woods, because that is the person he indicated he wanted to add to his witness list last week, and I granted his request to do that. I asked him twice. He did not respond to that. Based upon his failure to respond, based upon this court advising him that if he failed to answer that question, he would forfeit his right to present any additional witnesses, again, other than perhaps himself. I'll find that he has forfeited his right to present and call any additional witnesses based upon his conduct in this case. I would direct Mr. Brooks to the case of State versus Anthony, although that squarely dealt with a person's right to call to be themselves a witness in their own case. They talk at length in that case about how rights, even constitutional rights, can be forfeited by conduct. Of course, the right to be present can be forfeited by conduct. That was established in Illinois versus Allen. And then the right to present evidence on your behalf can also be forfeited based upon conduct. Although a criminal defendant does have a right to present a defense, doing so must be guided by the rules of evidence, the rules of procedure, and also with respect for the dignity, order, and decorum that is needed in the courtroom. Mr. Brooks has demonstrated this morning that he is not willing to answer simple questions about calling witnesses. He reverts back to raising the issue of subject matter jurisdiction, which, as this court has previously found, I believe is simply a distraction tactic, a delay tactic, and a disruption tactic. when considering that the court must be concerned not only with the defendant's right to present a defense, this court must balance that with preservation of dignity, order, and decorum, and the numerous procedural and evidentiary rules that control the presentation of evidence. Because in my findings today, Mr. Brooks has been unwilling to answer simple questions regarding the calling of witnesses. Again, I'll find that he has forfeited his right to present further witnesses. I would like to go through a number of advisements with Mr. Brooks regarding his right to testify. I will unmute him for that. I ask Mr. Brooks to put on his headphones if he is unable to hear me, and just to be 100% safe and secure on the record, I'd ask the bailiffs who are over there to advise him. I'm going to directly be speaking with him, and if he's unable to hear me, to put on the headphones at this point.
Mr. Brooks, you're unmuted.
He's unmuted.
You're unmuted. You can speak for everything you want, but you're not here. Can you hear us?
I've also been advised by not just the bailiffs who are over there, who I can hear through the audio, but also from the clerk who's in that courtroom, through my clerk who's in this courtroom, that the audio is very loud and clear. Mr. Brooks, I would like to go through with you your right to testify and your right not to testify. We are at the stage in the proceedings where it is important that this court conduct a colloquy with you. I will advise you that if you refuse to answer my questions, refuse to acknowledge me, you can forfeit your right to testify on your own behalf. Again, that's State versus Anthony, 2015, Wisconsin 20. Mr. Brooks, you need to be aware and are so advised that you have a constitutional right to testify. Did you hear me say that? There's no response by Mr. Brooks, and he does not have the headphones on, and he has a book in front of him.
He's really trying to
although I haven't
stop
seen a
this by
page
any
turn.
means.
If you testify, sir, the state has the right to cross-examine you. That means to ask you questions after you give your initial testimony. Did you hear me advise you of that?
Wonder who would have
No
questioned
response
him.
by Mr. Brooks. Sir, you also have a constitutional right not to testify. If you decide not to testify, you are further advised that doing so cannot be used against you, and I would so advise the jury. Did you hear me advise you of that? Once again, no response by Mr. Brooks. The decision to testify is for you and you alone to make. Did you hear me say that? There's no response by Mr. Brooks. It's my understanding that Mr. Brooks has the equivalent of a 12th grade education, that he attended school either up to or through 12th grade, and either has a GED or an HSED. There's been some conflicting information on paperwork throughout this case, but I'll find that he does have a high school education. He is currently in custody, of course, at the WAUKESHA County Jail. I'm not aware of any medication that he has been taking. Sir, have you taken any medication?
Okay. Sorry. Trying to get things moving again.
I'm not receiving a response to that. I'm aware that he's able to read and write English. I would refer back to the record made during my colloquy with him regarding the waiver of counsel and his ability to be aware of rights, his ability to, I made a finding at that point of his understanding, and based upon his conduct throughout this trial, including the waiver of right to attorney hearing, I'll make a finding that he has the ability and understand, he can read, write, and understand the English language.
Am I unmuted?
You've been unmuted the entire time, sir.
So what are you talking about? Is you talking about subject matter jurisdiction and how you gonna verify it on record?
So he
Prove it on record?
did not answer my question if the record's not clear about whether he's had any drugs, alcohol, or medication within the last 24 hours. I'll ask him, sir, has anyone made any threats against you to influence your decision on whether to testify on your behalf in this trial? Although he turned and said, what did you say? Again, I believe he's fully able to hear this court at this time based upon how the audio is functioning in the other courtroom. He did not respond to that. Has anyone made any promises to you to influence your decision?
You saying. So if you can hear me, I don't hear everything you saying, and you know I don't hear everything you saying. So cut the crap.
Cut the crap.
Mr. Brooks has interrupted with very disrespectful words at this moment. I believe that he is feigning his inability to hear and that he's done so throughout this case. There's absolutely no indication. He puts the headphones on when he wants. He takes them off when he wants to. While in this courtroom, he hasn't had them on. He's only used them while in the other courtroom. But again, I've confirmed multiple times that the audio is loud and clear. And his statements that he can't hear, his statements that when I mute his audio, that it mutes his audio, are simply false.
So
Mr. Brooks, have you made...
Am I still unmuted?
You are, sir. And I'll make a record that per the lieutenant over in the other courtroom, the volume is 2 to 3 times louder than it is in this courtroom.
You need to stop making false records saying that I said I can't hear you at all. I said I have trouble hearing you when I'm over here. That's what I said. So I would appreciate
you
if you
heard
would
her.
make the record clear and correct.
And correct.
Clearly, he heard me say that for him to make that distinguishing
Yeah,
statement.
I'm sitting right
So-
here.
Can't you see me? Can't you see me looking all up in here?
You can hear me?
I don't have an issue hearing you at all, sir.
I wish I could see him. Oh,
I
what
can.
a fool.
Once again, per the lieutenant who's been in both of these courtrooms, the volume in the adjacent courtroom where Mr. Brooks is at is 2 to 3 times louder than it is in this courtroom.
Yeah, what a treat.
Mr. Brooks, have you made a decision?
What about this courtroom?
Have you made a decision to testify in this case?
Now, have you made a decision to tell
I will ask you again, sir. Have you made a decision to testify in this case?
To address subject matter jurisdiction? Have you made a decision to be impartial? To answer what your name is? To answer if you have a claim against me or
I'm
don't
going to
you
mute
have
him
a
for the
claim against
moment just because, once again, he's attempting to divert away from what this court needs to do by going through the proper colloquy with him regarding his right to testify. He is asking me about subject matter jurisdiction.
Who knows what he's asking about her name? Is he asking because she may have become a lawyer or a judge when she was single and now has a married name and is different on her pictures and whatnot? Like he won't even acknowledge his own name. What the heck?
He's making statements about this court that are disparaging and about my oath. Again, a clear attempt, in my opinion, to simply stall these proceedings and to disrupt them.
Yeah.
I will unmute him and I will ask him for a third time with the understanding that if he fails to answer the
He's mad. He
question
thought he was
in
going
the
home.
affirmative, I will
Today.
interpret his failure to respond as a no and that he is not going to testify. So once again, I am unmuting him. Sir, have you made a decision on whether to testify in this case? There's no response by Mr. Brooks. I will ask it yet another way, sir. Do you want to testify on your behalf in this case?
Am I unmuted?
Yes, you have been. Sir, do you want to...
How long have I been unmuted? 'Cause you just
Sir,
said-
do you want to testify in
You
this
just said
case?
you was muting me when I had the headphones on just a minute ago. You just said you was muting me. So when have I become unmuted? Or did you even mute me in the first place?
Mr. Brooks, I'm asking you one last time. Do
ain't
you
asking
want
me
to?
nothing because I haven't heard nothing that you asked. So how you gonna ask me something and then just answer for me?
Mr. Brooks, do you want to
You can't answer
testify?
for me.
All right, I'm
You
going
can't
to
answer for
answer.
me.
I'm going to
You
move
can't
him
answer
again.
for me.
Again, it is very clear to this court that he uses the statement that he can't hear as a means to delay. It's a distraction. It's very evident that he hears this court and that he's choosing to willfully not answer this court.
Yeah.
This court, as I indicated earlier, is tasked with the duty to ensure that there is efficient and effective presentation of relevant and probative evidence in this case. This court is attempting to go through the needed colloquy with Mr. Brooks, and he at all times during this colloquy has refused to answer simple questions. I personally do not want to make this more difficult, but I must establish these ground rules that he must answer these questions in order for this court to make the appropriate findings. Without him providing answers, this court is left with no choice but to find that he is forfeiting his right to testify on his own behalf. This court must also preserve dignity, order, and decorum. Again, ensure relevant and admissible evidence is presented, and also honor the defendant's right to present a defense. The simple requirement that he answer questions is required, frankly, due to the defendant's prior conduct throughout this trial. His repeated defiance, his repeated outbursts, his repeated failure to follow simple rules of courtesy and decorum, his repeated interruptions of this court, and this court having to repeatedly remove him to the neighboring courtroom and making findings that he has forfeited his right to be present. Of course, this record is abundantly clear at this point that Mr. Brooks is not even in the main courtroom, because this morning alone he is yet to conform his conduct to the simple standards of courtesy and decorum that are required of all participants in these court proceedings: the court, the prosecutor, the defendant, the jurors, the public. Absent an adherence to these simple rules, including the rules of evidence, the rules of procedure, and the rules of civility and decorum, and without a pledge by Mr. Brooks that he will follow these things, then on balance, this court will find that he has forfeited his right to testify. I've now made a much more full record of what is at stake, and I will give Mr. Brooks an opportunity again to go through the colloquy with the court regarding his right to testify.
This is excruciating.
I am unmuting him, and we'll attempt to go through this procedure once again. If he fails to answer these questions, then he is forfeiting his right to testify by his own conduct. I would acknowledge that such a procedure is certainly not ideal, or making a finding that he is forfeited is not ideal, but as Mr. Brooks's conduct and Mr. Brooks's conduct alone that has forced the court to make this determination. So Mr. Brooks, you are unmuted. You have been for about a minute. I want to go through the questions again. Are you aware that you have a constitutional right to testify? Mr. Brooks, are you aware that you have the constitutional right to testify?
Are you aware that you're practicing law from the bench?
Mr. Brooks,
She's not.
do you understand and are aware that you have a constitutional right not to testify?
I don't understand. No, I don't understand.
Are you aware that you have a constitutional right not to testify?
I don't understand, and I'm not aware, so why are you asking me questions?
All right, I'll do this another way, sir. Sir, you are advised that you have a constitutional right
Whoa,
to testify,
good
and that
job.
if you choose to
I don't
testify,
understand.
that you would be subject to cross-examination by the state. Did you hear me say that?
I don't hear you say anything. I don't understand what you're asking. I don't
He is
understand.
willfully choosing not to answer that. Sir, you are also advised that you have a constitutional right not to testify,
Your Honor, with all respect, you've been trying
Did
to
you hear me say that?
answer questions for me. I didn't hear you ask me anything.
She didn't ask you anything.
And
Sir?
I don't understand.
Stop talking and I'll ask it again. Sir,
Can you ask me to stop talking in it?
I'm asking you to stop interrupting me so that you can hear the questions. Even though I fully believe you hear them, I will attempt to do
I
this
got the
one
headphones
last
on.
time.
You have to hear them. I got the headphones on.
All right, then let's.
Obviously, you can see that.
Once again, Mr. Brooks is being disrespectful. He is
He's a
blurting out
misogynist.
information. He
Monster.
reverts back to subject matter jurisdiction. He accuses this court of not honoring its oath. He just accused me of practicing law without a license. Again, all attempts to deflect away. I'm going to mute him once again. This court has simply tried to no avail to get Mr. Brooks to answer simple questions, confirming on the record that he has been advised that he has a constitutional right to testify, and that he also has a constitutional right to testify. I was very clear prior to unmuting him and telling him that I would go through these questions once again, that I needed him to follow the rules of decorum and civility and not interrupt this court. He has done nothing to demonstrate decorum. Again, repeated interruptions. It is, again, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. He reverts back again to things like subject matter jurisdiction, practicing law without a license. Then he makes requests about interlocutory appeals, etc. The record is full of his tactics in this case. He would not pledge to be civil, to be courteous. He would not pledge to honor the rules of evidence or the rules of procedure. He would not even answer simple questions regarding his right to testify and whether he heard that or not. And based upon, pursuant to State versus Anthony, and looking at the balancing test that this court must consider, this court simply cannot allow Mr. Brooks to get on the witness stand unfettered without an acknowledgement that he will honor the rules of procedure, that he will abide by the rules of evidence, that he will honor rulings that are made by the court. He has demonstrated repeatedly throughout this trial that when this court makes a ruling that he disagrees with, he tries to engage the court in an argument about the legal basis, even though I've provided the legal basis on the record, or in the case of subject matter jurisdiction, even when there's a written determination on the issue. When looking at State versus Anthony, this is a case where the Wisconsin Supreme Court was faced with a similar situation, although not as egregious as I would say here, because in State versus Anthony, that was not a case where the defendant was ever removed from the courtroom based upon his conduct. Although in State versus Anthony, they noted it isn't a requirement to forfeit your right to testify to previous to that be removed from the courtroom. So not as egregious as a case, but this court has a history over 15 days of trial where Mr. Brooks has repeatedly been removed from the courtroom, where he has repeatedly demonstrated he has absolutely no regard for courtesy and decorum. He is what I would describe as a stubbornly defiant individual who simply wants to say what he wants, when he wants, without a filter, without regard to the rules of evidence and the rules of procedure. As State v. Anthony discussed, the right to testify, although a fundamental constitutional right grounded in personal autonomy, is not absolute. For example, there's no constitutional right to commit perjury. There's no constitutional right to present irrelevant evidence. Moreover, a criminal defendant's right to present relevant testimony is subject to reasonable restrictions. Those restrictions, again, fall primarily under the rules of evidence and the rules of procedure. The court in Anthony cited the U.S. Supreme Court from Arkansas versus Rock, wherein that court stated the right to present relevant testimony is not limitless and may in appropriate cases bow to accommodate other legitimate interests in the criminal trial process. For example, numerous procedural and evidentiary rules control the presentation of evidence and do not offend the defendant's right to testify. Throughout this trial, Mr. Brooks has repeatedly accused this court of violating his First Amendment rights of free speech. I've told him repeatedly his First Amendment free speech rights are not unfettered and that they are limited in the court of law for the very reasons cited by the Supreme Court in Rock. The takeaway from Arkansas versus Rock is that a defendant may forfeit his right to testify by his conduct. Whether a criminal defendant may forfeit his or her right to testify through conduct incompatible with the assertion of a right was reviewed by that court. That court went on to discuss waiver and forfeiture and ultimately went on to conclude the following. We now conclude that the right to testify may in appropriate cases be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. The balancing test that this court must go through are the interests, again, as I've already stated, for the rules of evidence, the rules of procedure, civility, and decorum, and balancing all of that against Mr. Brooks's right to testify. This court is not making an arbitrary decision. The decision I make here today is, in my opinion, proportionate to the conduct demonstrated by Mr. Brooks throughout this trial, and specifically today based upon his failure to even engage the court in a simple colloquy regarding his right to testify and his right not to testify. He was repeatedly warned that the failure to answer the questions would be taken as by this court really as no, meaning the specific question, have you made a decision? And as for all of those reasons that this court will make a finding, he has forfeited his right to testify. With that, then, there are no other witnesses to present for the defense.
Wow.
Before I bring the
That's
jury
it.
out, I'll ask the state if you intend to call any rebuttal witnesses.
We have no rebuttal case, Your Honor, thank you.
All right. I would like Mr. Brooks to be brought
Made no
back
case.
over so that he is present in the courtroom when the court advises the jury that the defense is resting. I realize that will be over his objection. I'd ask that he honor that. Mr. Brooks, I'm going to unmute you. If you can pledge to this court that you will honor that ruling and that you won't challenge that directly in the presence of the jury, I will bring you back over for that. Are you willing to make that pledge, sir?
Make what pledge? I'm not making no pledges.
Sir, you are...
Oh my goodness. He's so exhausting. Okay. I am gonna make a break here because they're obviously gonna bring him back to rest the defense's case, and then we'll see if we can't muscle through the rest of this. I will see you later. I know this is a rough one. This is Patty Jo. Thanks for joining. Like, subscribe, dislike, whatever you feel. Bye.